Hi, and welcome to Season 1, Episode 14 of the Florida Family Law Attorney Podcast. And today we have a dear friend of mine, someone who's a seasoned criminal defense attorney, Rusty Shepard. And, Rusty and I have known each other for a long time. In fact, when I was a law clerk, before I was a lawyer, one of the first motions I ever saw argued in criminal court was the guy I was working with was arguing a motion to suppress against Rusty. And when Rusty was the actual prosecutor out in Washington County, I think he was still a baby lawyer then himself. It's been that long ago, but Rusty brings a lot of experience in criminal law and is just one of the most decent people I know and a good friend of mine. In fact, a little fun fact is when I got married, it was a rainy day and Mary and I were out there panicking, and Rusty ran up in the middle of the service and put an umbrella over Mary and I so we could finish our wedding vows. So Rusty and I go way back. And Rusty, why don't you tell us a little bit about yourself?
Well, I started out as a prosecutor. I went to law school over at Florida State. I ended up moving to the Panama City area. I love it here, and got a job as a prosecutor. At that time, my wife was actually a defense attorney here in Panama City. So they said, that's fine. We're going to hire you as a prosecutor, but we're going to hire you as a prosecutor up in Washington County, up in Shipley's. In a way, I will tell you, most people, when they go to law school, don't think, hey, I want to be a prosecutor in Shipley, Florida, but wow, what a great experience that was. Really got a lot of exposure for a lot of different kind of cases, and the quality of law and the people in that area, whether you're in Holmes, Washington, Jackson, Calhoun, or Gulf. And Gerard, you know this, the quality of law here in the 14th Judicial Circuit's really high. So it was really a blessing. I was able to handle felony cases very quickly, handled all of the motion work for a period of about a year and a half. Ended up being a prosecutor there in Washington County for about 4 years. Left the state attorney's office, came down here to Panama City and opened up my own firm in 2004. For the last 21 years, I've been a criminal defense attorney. We handle all kinds of cases, exclusively criminal. We're a full service criminal defense law firm. We handle everything from cases involving death to drug trafficking to 1020 life, which of course is standard ground. We handle sex crimes, which of course includes child sex crimes, which spill over into, of course, the family law arena. On the misdemeanor side, domestic violence, battery, those types of things, which again have a family law lead in, a family law pair, as well as DUIs and those types of things. I was president of the Bay County Bar Association for a 4-year period of time back in the early 2010s. I followed that up by being president of the Criminal Defense Bar here in the 14th Judicial Circuit for another 3 years. And I'm the managing partner of the largest criminal defense firm here in the 14th Judicial Circuit.
It's a great background, Rusty. And, I've watched you grow your practice over the years and grow as an attorney, from Washington County all the way up to owning your own firm and being a multi-attorney firm. So, Rusty, what I wanted to get you on about is so many of our cases in family law end up having an intersection with criminal defense and criminal issues. I have seen, what I thought were going to be just garden variety, maybe simple uncontested divorces just completely go south because of a criminal allegation. One of the parents gets accused of a DUI and now it's a full-blown custody case, or always seeing issues where people are accused of domestic violence or are victims of domestic violence, and then the criminal process starts, and it really affects the divorce proceedings and affects the cases. And there's a lot of people, I think, out there who just have questions, who are facing those particular issues. And it's something that, as a family law attorney, who has had some criminal experience, that, I feel like I can answer some of the questions, but of course I always try to send them to competent criminal defense counsel so that they get the best representation they can in both arenas. And it's, it really does change the dynamic of how those cases go. And then, I don't think a lot of people understand that there's a big interplay in civil cases and criminal cases, because if you go to your civil case and you testify and you say something and there's a court reporter, or it's being recorded through the court system on the Blue Man, it's what they call the in-court recorder, that can be used against you, and vice versa. So those are, things that I think that, people really need to have information about. And the whole purpose of this podcast is to help people who are facing family law cases, and in this particular episode, family law cases that may have a criminal component, unfortunately. So, Rusty, in your practice, where do you see the most intersection between family law and criminal law with your cases?
And I'll tell you, Gerard, I would say a very high percentage of the cases that I deal with on a daily basis have some bleed over, or certainly the potential for bleed over. I mean, we can start, kind of with the misdemeanors and work more towards the felonies. But a lot of times, one of the difficult things, well, if you have, and this would be a question to you, if you have a divorce proceeding, a family law proceeding where everything is equal, well, not everyone's a good player. So how can they create an advantage, right? It's one thing to say things about someone. It's another thing to say things about someone and get them arrested, right? And so often what we find, and it's very frustrating in my practice, what we're really after is a full, thorough, and unbiased investigation by law enforcement. And many times in the family law arena, when it bleeds over into criminal law enforcement, they're unable to do it, or maybe they don't follow up quite as we wish they should or would. And of course, the reason why is a lot of times you have someone who's trying to create that advantage, and they're going to make it in a way that it's unanswered for. So when you have something like a domestic violence battery, by the way, is defined in Florida as any unwanted touching. That's a battery. Now, there's some common sense that goes to that, but at the end of the day, it doesn't have to leave a mark. It doesn't have to be closed fist. It can be a push. It can be bumping a shoulder. It can be any number of things. And they're very serious about these battery cases, especially when it gets into a domestic relationship. And I'm talking about law enforcement, and they should. There are all kinds of studies where higher level offenses many times start with a behavior that's violent and domestic violence. But
It's
I
kind of
say that
it's a gateway crime in some ways.
it is, but I say that to say, you know what, they can't leave it unanswered for. So when there's an allegation, they're going to make a report, whether the person that's being accused is there or not. And they may not be able to get up with the person accused, or it may be a second officer that actually makes the arrest, in which case there is no other side of the story. So effectively, just based on one person's accusation, suddenly we have a criminal charge. And Gerard, you've done some criminal law. It's a very difficult thing. I mean, one of the things as a criminal defense attorney they say is, zip it, right? I mean, the last thing I want anyone doing is giving up their Fifth Amendment right, which is effectively the right to have the state prove the case against you, and because then they're forced to stand on their own evidence or lack of evidence. So, there is a lot of bleed over. I think a lot of times people are trying to make that advantage. There is sometimes some self-injury that is associated with these things, red marks, they'll say, and these types of things, which I would say many times are not serious injuries and can be self-inflicted by the person. So there's bleed over. And certainly I don't want to say there is not domestic violence, because there absolutely is. But I would say a lot of times the challenge for us is, here you have someone who's effectively like somebody going through a family law issue, and suddenly you reach a contentious point within that family law proceeding, whether it deals with a child or an asset or something like that, and suddenly here comes this criminal allegation, and I'll let you speak to this, but that allegation is something that I believe to create can be used to create an advantage in family law court. We're
No,
focused primarily
absolutely.
on freedom, not the family law side of it. So it's a challenge from that standpoint.
Absolutely. Family law, covers a broad penumbrum of different categories. You have, domestic violence injunctions, you got the divorce, you got equal distribution and alimony. However, the one that domestic violence, I see it pop up the most is in child custody.
Yeah,
Because if you are convicted of a domestic violence charge, it can create a presumption of sole parental responsibility and no time sharing.
it's
Sole meaning that you don't even get to participate in any decision making with the children. And if it goes as far as no time sharing, you no longer even get to have time sharing with the children. And that's in the Florida's child custody statute 6113. So when we have people who come in here and they're facing these serious allegations of domestic violence, and there's a custody component, that's usually the first thing my mind bullseyes onto and focuses on is, how are we going to overcome this? Do I need to delay filing the case? Do I have to, to give the criminal defense attorney more room to run? What do I need to do to block, maybe stay proceedings, whatever I can do to drag out the case? And it's not to drag it out, in a malicious way. It's drag it out to see if the criminal defense attorney can, find justice for the person, and perhaps that person was falsely accused and they're innocent, and trying to build, build them enough runway there to take off and land that plane and get done with that case before I proceed and end up, getting in the way, or us going to court when the facts are not completely, settled out yet as to what happened and if the person's innocent. So, yeah. Now, for people out there who are listening, Florida also has in the child custody statute a section that deals with false accusations of domestic or sexual violence. So, if you are acquitted, or if it's found out after a thorough investigation that there's no way that this happened and it was completely a false allegation, like Rusty was saying, self-inflicted wound, or somebody just trying to get using a very nasty tactic to get some kind of advantage in the divorce or child custody case, then that can be used against that person in the custody proceedings. Because the court does not reward that bad behavior, but we have to prove it, and that's usually a combination of the criminal defense team doing their job, and then the family law attorney following suit on that, and taking that information and running with it in that case. So yeah, there are also cases where I've read coming out the appellate courts that have given a domestic violence victim lump sum alimony. Hey, just take his entire retirement so he doesn't have to pay you a monthly payment anymore, but take the entire retirement. That way, you don't have to interact with the person. You don't have to, pick up a check or give them your address or anything else. There's no more interaction between the two of you. So, yeah, domestic violence specifically is one. Violence or sexual abuse allegations, or fall into that penumbrum of kind of domestic violence type situations. Those are critical to overcome if you've been falsely accused, and also, from our standpoint, if the person did do it and I'm in the middle of their family law case, my job as their lawyer is to guide them to competent legal criminal counsel if I find out about it first. Because what I hear a lot, and Rusty, maybe you can speak to this, the cops came out and I didn't get arrested, and they think that it's over. And then what happens is it's been sent to the state attorney's office for review. And a couple of days or weeks later, unfortunately, they get arrested. And then, and they think they've been scot free. They think that, hey, that was over. It was done. They've been on Facebook. They've been talking about the situation. Can you speak to the review status, Rusty, and how that works? And so people know that maybe if you do not get arrested on the spot, that there's still potential for an arrest potentially.
Yeah, so we see that a lot. And I will tell you, particularly in issues where there are child custody disputes, excuse me. And that's really the law enforcement officer who's the person who's on scene making a determination. Presumably the person who's involved with law enforcement who knows the most about the case, right? The person who's on scene, who's talking to witnesses, saying, you know what, I don't know that there's enough right here. I don't know that there's enough to go ahead and say that there's probable cause to go ahead and make an arrest. But it's a domestic violence situation. These things escalate. We take these things seriously. I'm not going to make that call. I'm going to pass it on as something that they call a review case to the state attorney's office. And what happens at that point is the case goes over to the state attorney's office, and an on-call attorney, and I don't even know that they know sometimes day to day who the on-call attorney is. It may be a senior prosecutor. It may be somebody who's a year out of law school and getting used to misdemeanors. But that person ultimately is going to make a determination on whether or not someone should be charged and have to go to court on a charge. And that's a really difficult thing from our standpoint, because what we find is the state attorney's office, they're pro-charge. If there's any question at all, 9 times out of 10, we find that they go ahead and they do it, right? Their idea is, we're going to let the court case figure out exactly what happened. Whether that's something that is, felony where you can take depositions, or whether it's a misdemeanor, they're very pro-charge. And it's a frustrating thing, because a lot of times what's happening during that delay is any evidence, witnesses, all of those types of things that can be used to formulate a defense is gone by the time the case actually comes through. So it's a very frustrating thing. But yes, that's certainly an issue, as you well know.
Yeah. Well, one thing that, we see, a lot of is domestic violence injunctions, which is not a criminal case. It's a civil proceeding where if you're the victim of a domestic violence incident and you're in imminent fear of repeat harm, or maybe already experienced multiple occasions of harm, that you can go down to the courthouse and petition for an injunction to ask the person that's the abuser, or for the court to order that the person who's the abuser to stay away from where you live, stay away from where you work, where you go to church, children's schools. And there are lots of cases I've seen where those are 100% legitimate, and there are cases where I have seen people try to abuse that. And what I call it is the quickie divorce. They're usually done. You get served with papers about 2 weeks' time. You're in court. There's limited discovery. You get a 15-minute hearing. If you do not prevail on that, the judge will say, "Hey, I'm going to send you out to the house with a sheriff's deputy to get some basic belongings." Then you're not allowed to come back. You're not allowed to be around the kids. A lot of times they'll give 100% time sharing to the alleged abused spouse, and they can even give alimony and child support. So for a person who is unscrupulous and maybe is looking for, the quickie divorce to, try to avoid, the long family law process and go ahead and get basically 100% custody, to get alimony, to get child support, to get temporary exclusive use of the house, that unfortunately can be achieved by an unscrupulous person in a DV case in about 14 days. In a family law case where we're going in a much slower pace, but we're allowed to do discovery, we're allowed to depose people, get down to the facts, and do a much more thorough investigation that could take months, and you have a lot bigger time frame to argue the facts of the case than, maybe a 15-minute domestic violence hearing. We see those intersect. And then, a lot of times, depending on how unscrupulous the person is, if it's not a legitimate claim, they've reported it to the police. The police will give them a packet or a pamphlet that explains the injunction process as well. A lot of times they have literature on them. So you have the criminal charge of domestic violence. You have the civil injunction that's getting filed if the person pursues that. And you have the family law case. So now we have three balls in the air that we're juggling, and we don't want to step on anybody's toes in this process, because I don't want to mess. If Rusty's your criminal defense attorney, I don't want to do anything that's going to mess Rusty up. Rusty doesn't want to do anything that's going to mess me up. So then we have to work together to collaborate, timing, who's taking the lead. I have done domestic violence injunction cases where I'm there as the family law attorney, the criminal defense attorney is there as the criminal defense attorney, and now we're working in concert together, because I call the injunction quasi criminal. It's not a criminal proceeding. You're not going to jail at the end of it if you show up for court and maintain composure. You're not, it's just going to be an order that says stay away. However, it's quasi criminal because it's, whatever is said in there is going to get used against you potentially if you decide to waive your Fifth Amendment rights. If something egregious comes out in the domestic violence case and you haven't been criminally charged yet, if you somehow admitted to it, or the evidence is very strong and someone takes that to the state attorney's office, they may decide, like Rusty said, to review it and decide to prosecute on it. So, Rusty, tell us about how domestic violence injunction cases affect, ancillary criminal cases that are going on at the same time. When we have both of these cases going on, how one can hurt the other and how you can really shoot yourself in the foot. And as a criminal defense attorney, what advice would you give that person and that family law attorney, who's in that position where I got the family law case over here, now I got the injunction, I know there's a criminal case. Can you help us juggle all three of those balls so that we don't drop anything?
Of course. And so let me say first and foremost, and I think the most important thing when you're in a situation like that, you need to have a legal team. And when I mean legal team, whether it's family law, criminal, or any additional other types of areas that the case may spill over into, that's working together, right? One of the things that I look for, that we look for as a firm coming into a case, is what's our goal? What's our target? What are we trying to get done that can help the overall situation? So, I think it's imperative to get a lawyer on retainer as soon as possible when you're dealing with these things. As Gerard, as you said, they move very quickly. They have extremely strong repercussions. We didn't talk about this, but just the domestic violence battery as well as an injunction. At that point, your firearms rights are gone, right? These have implications outside of just a spouse, a divorcing spouse, or children. These are huge things.
I'll tell you what other people don't realize with the injunctions. People are like, oh, well, I didn't want to be around her anyway. I was done. I'm leaving. I'm getting divorced. I don't want to be. So why would I fight that? Or why would I bring this up and, spend the money and time and effort in defending this? And I have heard recently and had some experience with people trying to get jobs and they run the background checks and the injunction shows up in the background check. And so if you have a job, perhaps where you're working with the elderly, working with children, maybe requiring clearance to get on a military base, and that can become a red flag long after the divorce and long after the injunction hearing that continues for a long time on your record.
And one of the things that I would say, Gerard, and you do this a lot as well. This is part of the bleed over here. I think so many times people get these accusations and they just throw up their hands. I don't know what to do. I can't deal with this. But so often when we start digging into a case, and again, there's bleed over, so we're digging into it as are you. There are defenses. The way the legal system works is we're able to bring out the facts, and many times, most of the time, that leads to all kinds of things that can be argued and incorporated into a defense that, of course, not only is going to help in an injunction and a criminal court, but also as part of the family law court, I would imagine as well.
Yeah, you know what I really like is as a lawyer, it's one of the things that's kind of the high point of my job. When people come in and they've been accused of something like this, and you can see on their face this look of defeat or just overwhelmed, the ostrich in the sand, just gonna stick my head in the sand and I don't know what to do and I'm overwhelmed. And then when you get in there and you start, reading some of this stuff or you're asking them questions, and I never will forget one factual scenario of a case where there was a domestic violence injunction, and when you looked at the date of the allegation, and then I said, "Give me your phone if you don't mind." And I said, and I scrolled through the phone, and after the alleged incident of this horrific violent act that was accused, it was, "Baby, I love you. When are you coming home? I really want to be with you in an intimate way." And I was like, that does not sound very consistent with someone who just, committed this atrocious act that's been accused. And, and that you can kind of see sometimes the light come on inside of them, that there's hope, that there's a chance, and, helping them that because, when when you really accuse somebody of domestic violence, when you falsely have done that, I mean, it's pretty horrendous character assassination if you are not if you're a gentle person who's not violent, to be put in that category. It's kind of devastating to their psyche, I think, and I think it's a lot for them to overcome. And a lot of these people are good people, and now in public, in court, are this is all going to come out, and they're going to hear these horrible things about me, and then being able to tell their story and to get that story out, in that. But my advice to them is this: if the cops have been called, if I have any inclination that the police were involved with this at all, of course, I'm checking the docket to see if I see any criminal filings. But sometimes you can't even see that until the warrant's been served because it's sealed off until then. Then I'm still sending them to the criminal defense lawyer because you mentioned it earlier. But the Fifth Amendment, the right not to incriminate yourself, may be coming into play in any of these cases. If you're going to court and you're talking, or you're giving a deposition, you're talking. So, Rusty, if there's been quasi-criminal, or criminal allegations that are made, the police have been called. Can you explain when you should bring the criminal defense attorney into the picture? When is that something later? Is that early on? And kind of explain how the Fifth Amendment works, and how what that means to the cases and how they proceed and what we do as lawyers.
I would say bring them on immediately. Like yourself, I'm a father, so I'm going to tell you. I sent my child away. She goes to school out of state, and I sent her with two rules. You don't talk to the popo without a lawyer. You don't do it. They will always, and I mean always, let you give a statement later. Okay. The second thing is you never consent to a search. And those are the two things. But if I could draw attention to one other thing, because this is a major takeaway in my world, you know, people will say, well, there was this text back and forth and, they said this and, that doesn't jive with what was happening. Well, where's the text? Well, it was erased. You never erase a text. I cannot think of any reason, regardless of who it's from, to ever erase a text. That is the best evidence. People tend to think, well, the cell phone companies keeps text messages and we'll go back and get them. No, no. They take record of the fact that a text was sent, but they're not actually capturing the words. So the words are on your phone and on the phone of the other person. And what we run into a lot of times is they erase parts of the text message and then they give it to law enforcement and represent it to be a true and accurate conversation.
Hmm.
And the frustrating thing sometimes is we say, well, where is it? Well, we don't have it. And that's awful because at that point, that would have been some truly exculpatory evidence that we're deprived of within a case. So if there is one huge takeaway, I would say do not erase text messages, do not erase emails.
I'll tell you.
These are
I'll,
critical pieces of evidence, and they're timely because they're stamped.
I'll tell you one. I got one better than that. You were talking about the erased, deleted messages. I've seen that one. A lot of things now, like in the Apple ecosystem, are linked. The iPad, the phone, the MacBook. If you have a linked device system like that, what we had was a person who had the other person's iPad. They would send a message from the other person's iPad, then it would go to that person's phone. They would respond, then they would take the iPad and they just fabricated a back and forth of communications through the iPad. And we actually the iPad was using a Wi-Fi,
Mhm.
and the phone was using cellular. And so we had to show that the phone was not sending those messages and that it was this iPad that was taken from the client when the other party moved out the house and they separated. But they were able to fabricate a full exchange of messages back and forth by doing that. That's wild. But yeah, leave your stuff to save. Don't have it auto delete. Is a good one. If you have a cloud service, sometimes backing up to the cloud. I know in one case we had an issue like that come up, and we actually had to call a firm out of Birmingham that does forensic phones
Mhm.
and forensic iCloud. And that was let's put it this way, it's much cheaper to not delete them than to pay the experts in hopes that they can scrub and find and get into some kind of a cloud backup to get it, or that it existed. That is not cheap, and it's
That is
not
some
a
fancy
fast
forensic
process.
science.
Yeah. So you bring them on early. You talk to the criminal defense attorney, which is same thing I would say in my playbook. If the police are called, they show up, just go ahead and call. Tell them that I'm not trying to be rude, be polite. But I want my attorney. Call your attorney, get your attorney, or tell them you'll give them a statement. Perhaps after you confer with counsel, but that's going to be counsel's choice. And be mindful of the Fifth Amendment. Rusty, what does the Fifth Amendment really mean?
It means that the state has to be able to prove the charge without any evidence provided by you. It means that you have rights that you don't have to speak to law enforcement. It really revolves around the presumption of innocence, and what that really means is that the state has to prove it, right? So you have a right to say, you know what, I'm not going to add evidence here. I'm not going to say anything. You can't prove it, state. And so I think that it's a really critical point. I think that it is extremely important not to give a statement. What I tell people immediately, what I tell people is, listen, when they call me and there's an ongoing investigation, we handle cases pre-charge. That's a common occurrence for us. Many times their investigations, law enforcement, if they're doing their job right and they realize there's a family law issue, they're going to look at the case a little harder, or at least they should look at the case a little harder. And what that means is many times they're not just making a snap judgment. In that case, sometimes they'll reach out to someone who's being accused of a crime. And one of the things that they'll say is, hey, you listen, I'd love to take a statement. If they're reaching out to me, I'm going to call that law enforcement officer and say, hey, what's up? What you got? Where are we with this? Have you made a determination? Those types of things. Of course, I'm going to sit down and I'm going to talk to my client. I'm going to try to get as full of a picture as I can, because the reality is, if my client, I think the pat answer, the standard answer has to be, do not talk to law enforcement. But Gerard, if you're conferring with an attorney and you've conferred with your criminal law attorney, you've conferred with a family law attorney, there are times where, what, it may make sense, but that's not going down to the sheriff's office or a local law enforcement agency and sitting in an interview room and having them grill you or try to take what you're saying out of context. For me, and probably for you as well, what, that's like, hey, We're sitting in after thoroughly talking it through, after figuring out all the strategic ramifications, the pros, the cons, how it could play out in court. And that's, of course, on my side it's criminal, on your side it's family. You know what? It really may make sense. But that's sitting in my conference room with me present and inviting that law enforcement officer in. And if that law enforcement officer starts getting sideways, that's timeout. Timeout. We're kicking you out of the room so that we can confer. And that really might be the end of the statement. That is the only way that I can think that would be a good way to give a statement. So the answer is not always no. The other thing too is people really do believe, hey, listen, if a law enforcement officer asks me questions, I have to answer. No, you do not. This is America. So many times people confuse the power of law enforcement with patriotism. No, no. Patriotism is that law enforcement officer respecting your right, your Fifth Amendment right to remain silent and confer with counsel. That's what America is.
Well, as kids, at least our generation, as kids growing up, we were taught to have a lot of respect for law enforcement. And I still do have a lot of
Of
respect for law
course.
enforcement because they put their life on the line daily to make sure everyone is safe. However, I don't think a lot of people really understand the psychological dynamics of the police showing up and saying, I need to talk to you. Because we have been ingrained, from the very beginning, when we're small kids, if you get lost, you get separated from me, grab a cop, call the cops, call 911, to trust and, to cooperate because we are good Americans. And that's a root instinct for good people. People who have a lot of experience with criminal proceedings or they have a gut instinct the other way, right? So if you're a good person who's always following the rules, who's always lived in the norms of society, it's very sometimes counterintuitive to look at a police officer and say, not today, not now, I would like my lawyer. And people, I think, feel like they're guilty because they invoke the right, but invoking the right is your constitutional right to not self-incriminate and to not be put into a position where you're having a person, an officer, maybe an unscrupulous officer, put pressure on you. And I mean, I remember when I did criminal law that there was allegedly this confession that took place because the person didn't invoke the Fifth Amendment. They didn't invoke the Sixth Amendment to have their attorney present, and they gave the statement. And so allegedly there was this long, drawn out confession. But guess what? It wasn't recorded. There was no video recording. There was no audio recording. And I remember asking on cross examination, does the sheriff's office not have enough? Or what's the budget of the sheriff's office? And in that, whatever it was, $10 million, whatever, did y'all not have the money to go to Best Buy and get a digital recorder? Do you not? Well, we have them. We didn't have batteries. Do you not have the money for the batteries? How many years have you been doing this as an investigator? In that time, has no one ever, taught you or any of your training experience ever led you to the conclusion that perhaps you should have the recorder on? Because there are times where we've had cases in the 14th Circuit, unfortunately, I think, where there have been alleged confessions that that didn't actually take place because another agency had a tape recorder on and the one agency didn't know they had the tape recorder on. And when the criminal defense attorney found the tape recorder, if I remember correctly, there was no confession. It had went down a different way or they had invoked rights or something of that nature. So having your attorney there creates a record, it creates protection, it creates someone to take the pressure off and who knows the rules. And I tell people all the time, I'm a nice guy. I don't want to be the bad guy, but push comes to shove, let me be the bad guy. I will tell them, I did criminal offense. I will tell them, hey, that's enough. We're done, or we're not talking. Or in a family law case, I'll be the bearer of bad news that we're not accepting that settlement. Let me do the talking. Let me be the bad guy. That's what you're paying me to take the pressure off of you and help you in this time that you're under a lot of pressure. So, Rusty, if I want to invoke the Fifth Amendment, what do I have to say to invoke the Fifth Amendment?
I want to talk to my lawyer. I don't wish to speak to you.
Okay. It's that simple, right?
It is that easy, but it is much more difficult than that, Gerard. And if I can,
Yeah.
Can I share a quick story?
Yeah, absolutely.
So this is me, and I was back when I was president of the bar, so I don't know, 14, 15, something like that. And we had a fundraising event, or maybe it was First Friday, which I think, or not First Friday, but it was a Saturday legal clinic.
Saturday morning legal clinic, man.
Saturday morning.
I spent years there.
Yes, you did. And so I was late going into one of those, and I'm headed there, and I'm on the gas, and sure enough, FHP's coming the other way and turns around on me, and I'm like, oh my gosh! And at the time, we live in Florida. It's hot. It's July. Today's going to be a hot day, right? So I've got dark tinted windows. You can barely see in it. Guy comes up to me, and of course, here I am. I'm a criminal defense attorney, right? I've been practicing as a criminal defense attorney for, better part of 10 years. I've been an attorney for 14, 15 years right here. Guy says, an officer says, or a trooper says, hey, why I pulled you over? And I'm like, because I was speeding. Oh, dang it. And then he's like, yeah, hey, your windows look a little dark. You think that tint's legal? I'm like, absolutely not. And it's like, and so he's walking back to his car, and I'm thinking, oh my gosh, I just literally did everything I tell my clients not to do. I should have just shut up. So it's ingrained in us and we're taught as kids to trust law enforcement. They're here to do, a good work. And I need to be clear. So first and foremost, I don't know that there's any criminal defense attorneys who are for crime, right? What we are
Right.
really doing is protecting people's constitutional rights. And one of those rights is to have the state prove the case against you. And I need to say this, the vast majority, and I mean vast majority of law enforcement officers are honest and hardworking, and they see it as a calling, as their calling to protect and serve the community. They're
Right.
fantastic people with a fantastic role that are ridiculously underpaid and have a really difficult job. I will tell you as a prosecutor, we would hold seminars, basically case updates, case law updates for our officers, and the number of hoops that they have to jump through to stay constitutionally legal, protecting people's rights while investigating crime, it's a really long and difficult list. I'll be honest with you. As a prosecutor, I said, listen, first goal of being a law enforcement officer is to make sure you go home at the end of the night to your family. I mean, I think we need to recognize these folks have tough jobs, but we also need to
Absolutely.
recognize they have a lot going on, right? Because they're trying to protect constitutional rights. They have somebody who's made a serious accusation. They're in the process of gathering evidence. And many times they're not equipped to handle all of the things that are going on right there at the scene because it's happening fast and it's happening in real time. And that's why I say, a lot of times we're able to go back and say, hey, listen, there wasn't a full, thorough, and unbiased investigation, and that's, certainly we want that in every case. But the reality is, even the best law enforcement officer isn't able to provide that all the time. So, you know,
Well,
I think
I,
I think it's important for us to say, certainly law enforcement has a critical role within our community, but my job is to protect my clients, and your job is to help them in family law court and preserve that family. So that's
well,
we are not looking at the community as a whole. We're looking at individual people, and we're protecting constitutional rights, one client at a time.
I used to think when I did criminal defense that, what made our job great was I had time on my side. I'm sitting at a conference room table. I'm reviewing the file. I'm watching the video. I can back the video up. I can do all these things. And then, you could become, adversarial with the police as a criminal defense attorney, and you can start to think of it that way. But I think one of the things that I always, really took out of it was it's easy for me to Monday morning quarterback this when I can back the tape up 10 times. I can slow it down. I can read this 100 times over and think about it. I'm not in a parking lot in the middle of the night with the siren light flashing, approaching a car where there may be somebody there who wants to harm me or take my life. So my decision making as a lawyer and my convenience of backing it up and looking at like they have to make split second decisions so that they go home. And sometimes those decisions are right and they're trained to try to make right decisions and good decisions. And sometimes those decisions can be wrong, but it's not their fault because, they can't. I remember watching, and Rusty, you probably not to make light of it, but if you watch a DUI video when there's 3 or 4 cop cars out there and the sirens are going off and I'm watching the video is enough to almost make you want to have a little epileptic seizure.
Yeah.
It's a lot going on. And, coupled with, the fear of this person may try to run, they may try to harm me. So they have a really extremely tough job, and like nothing here, should ever be construed as not being appreciative of that. But at the same time, if there's an error, then that error should be exposed. Rusty, I know one of your practice areas is false allegations of sexual abuse, which is something that comes up, and you see that you want to add to the mix. You can have a criminal case if there has been some kind of a false accusation regarding some kind of a child abuse or child sexual abuse, a dependency DCF case, an injunction case, and the family law case. And that even gets more interesting because in the DCF case, of course, you're entitled to counsel. If you can't afford counsel in a dependency case where they're going to state maybe taking your children from you, then they actually can appoint an attorney, much like the criminal system as well, to assist you with that if you can't afford one. So, Rusty, do you see cases where one of the parents has put the child up to saying something that egregious to try to gain an advantage in the custody case?
Absolutely. And it's the most surreptitious, awful abuse of the legal system, but it's one that, unfortunately for the person that's doing it, gives them short-term benefit. So let me hit you with a scenario. You may have a husband and a wife who have a biological child, right? And then you have one of the spouses who has a child that they brought into the marriage, so effectively a stepchild to the other spouse. And what you'll get is you'll get that stepchild going into some place where there's going to be a mandatory reporter. So in other words, not necessarily the parent, the divorcing parent, that is making is I guess reporting the allegation. It'll be a nurse, it'll be a school nurse, it'll be a teacher, it'll be somebody else. And many times these allegations, they're latent, right? So they'll say, well, back 3 years ago, or maybe it was 5 years ago. So now we're dealing with this crazy amount of time where it becomes really difficult to build a defense, because they'll say, well, I can't remember if I was 5 or 8. It might have been when I was 6 or 7. And now you have this huge period of time, many times that can be 5, 6, 7, sometimes even 10 years ago, because the statute of limitations on child victim sex crimes doesn't exist. I mean, they can always come forward with those things. So that mandatory reporter goes and reports it to DCF or to law enforcement. DCF comes in and gets involved. And DCF in these things is a very difficult. It's a very difficult agency to deal with. DCF has a fantastic mission, right, to protect children, to protect families, and to make sure that everyone is safe. The execution of that, however, many times can be wanting. It can be not what it should be. And a lot of times in cases like that, really, when you're getting a visit from DCF, you're not really getting a visit from DCF. What you are is you're getting somebody who's coming in saying, I'm not law enforcement, give me your side of the story. That is later going to be called as a witness against you. And so that DCF worker comes in, basically gets a statement, they then, or not, and then goes to law enforcement, straight to law enforcement. And they'll take that child, that stepchild, they'll take them to the Children's Advocacy Center, which is an agency that helps gather evidence for law enforcement of child victim crimes. They have doctors there, but importantly, they have forensic interviewers. A forensic interviewer is an interviewer who is not supposed to suggest answers. So, for example, if I was asking a question that was suggested an answer, that would be a leading question, Gerard. And I'm going to ask you, are we both wearing blue shirts?
Yes.
So the answer has been suggested in the question. So this interviewer is supposed to not suggest any answers and just take them through it. It's videoed and audio recorded at the Children's Advocacy Center, and that becomes effectively a sworn statement from that stepchild about potential abuse. At that point, law enforcement officers are off to get a warrant. Now that parent, who, remember, has a biological child that is probably in dispute within the marriage, right, is
Right.
now arrested, taken to court, and at first appearance, the judge gives a bond. Now, those are serious crimes, and a lot of times, if that child is underneath the age of 12, you really could be looking at life in prison. Life in prison in Florida means life in prison. It doesn't mean 25 years. So, the bonds in those kinds of cases are significant. And then the other restrictions that the judge does is he says, listen, if you do bond out, you can't have any contact with the victim or any minor children, right? So now, guess what? That divorcing spouse now has both kids and the house, because you can't go to the house,
Right.
right? And so and then this is where we start to bleed over into the civil, right? Because the next thing they're going to do is that divorcing spouse is then going to move for an injunction. And at the injunction, they're going to ask for, of course, no contact. They're going to ask for child support. They're going to ask for exclusive use and possession of cars, of houses, of those types of things, and potentially alimony as well. And all of those things can be given in that very small hearing that is an injunction. And then, of course, once that's done, and this is your realm. Actually, it's both of us. We have to come in and kind of pick up the pieces, right? And it's not that you can't fix that. It's not it's not that you can't overcome that set of facts. It's that it really does take a lot of work, and it takes the experience of understanding what all the factors are. That to go into it. But effectively, what has that divorcing spouse done? They've litigated the entire divorce and child custody by having their own biological child, the step parent's stepchild, effectively make an allegation that just effectively allow them to litigate the entire divorce, at least temporarily.
Well, when you think about it, too, you have the criminal case. Obviously, if you're looking at, a life charge or a serious felony, that's probably the one that's got the most emphasis on it. So you may not be able to give a statement in the DCF proceeding or testify if you don't get that stopped, pending the outcome of the criminal case. The domestic violence injunction is the same way. While I'll generally ask for a stay of proceedings, lots of times those unfortunately are not granted, even though there may already be a criminal no contact order, but I will ask to stay it in most cases. Because again, if I have you testify and it doesn't go well, then that's ammunition for the dependency case and the criminal case. And so hopefully, your criminal defense attorney does a good job for you. The jury sees it your way, you get acquitted. Now we're trying to dig out on these other cases. And while a domestic violence injunction is a temporary transitory order and the divorce family law case supersedes that, it's already kind of set an unfortunate precedent of maybe alimony amounts. Hey, she's already got the house. The kids are used to that. Like, maybe she needs to make payments to you to buy it out from you, but I don't want to put the kids through that. But I'm going to tell you something too that people really forget about is each one of these cases has a different burden of proof. The criminal case is beyond a reasonable doubt. So my law school professor was like 99.9 beyond a reasonable doubt. The dependency case is clear and convincing. That's almost like 75%. Then the domestic violence injunction and the family law case are preponderant. So 51% wins. So I have seen cases in the family law that even after the criminal defense attorney does a great job, the case proceeds, you get acquitted, the state throws it out. I have seen people in the domestic violence realm in those injunction hearings in the family law court say the police arrested him, so they at least had probable cause, which is very low, like 51%. It's just probable. And so it's still not in the kid's best interest because even though they didn't get convicted, it still was probable and there's enough evidence to still do that. So when I tell people the famous case, the OJ case, the OJ Simpson case is kind of the one that I think, at least for now, people still remember and resonate. Remember, he was acquitted of the criminal charges. And then there was a civil suit and it was wrongful death civil suit and they won and got millions. So you really are, if the criminal is up here, but just because you don't get convicted doesn't mean it can't roll down to those lower standards. So you have to attack it on all fronts and have in mind those varying different standards that maybe there's not enough evidence to convict at 99%, but if it's 51 wins, 51%, there may be enough evidence to support that. And then with kids, it's just what's in their best interest. So you do hit a lot of judges and a lot of individuals who'll say, if you had an allegation like that, that's all I need to hear, that there was a serious allegation and DCF got involved. And then it's very hard to prove and to get that person's mind to open back up about you, that you truly are in the kid's best interest, that, it's that you're not that person. So, attacking and defending all these things at all different levels is just absolutely crucial when it comes to child custody cases. But Rusty, I can see you're chomping at the bit here.
Yeah, I was going to say, if I may, and this is a question to you, right? So we end up litigating a lot of those types of cases. There's something that when I was a prosecutor, I prosecuted them, child victim crimes. As a defense attorney, I've always handled them. We handle quite a few of them. And what we're looking for, just to be clear, because and this is kind of leading up, I'm laying the foundation for my question here. So a lot of times when we start out, we're looking for contradictions, right? Does the story make sense from a physical standpoint? Could it have happened the way that the alleged victim is saying, hey, this is how it happened? Are there witnesses? Are they going to effectively sponsor what the alleged victim is saying? Are there other statements that have been given that are contradictory? So, first we're kind of looking at that sort of in a little bit of a vacuum. And then we're looking at all the other things that surround it, right? Why would this allegation come forward? Because when you have a bias, when you have a why, a few minutes earlier, we were talking about, a stepchild, right? Well, that stepchild's for their biological parent, not for their biological or not for the step parent, right? So yeah, you've got an extreme bias here. And what's to gain? A lot is to gain, right? So many times in working those criminal cases, we're able to leverage that. And I will tell you, there's one thing state attorneys, assistant state attorneys do not like being used as, and one is family law attorneys. They don't like, listen, they don't like that stuff. Now, they have to take their job seriously, and obviously, child victim crimes are something they take extremely seriously, and they should. But when we start to get into the facts that there's such an extreme bias, and you have these statements that don't make sense, they start backtracking as far as what their offers are, and what once looked like this fantastic great case to them suddenly starts whittling away. So I guess my question is, because we're able to actually focus on that particular allegation, and you're deploying a many times a private investigator to go help find evidence and witnesses and things like that, public records requests. So here's my question to you. There are many times when our case is complete where we've got this body of evidence that we share with the client to take to the family law arena. How does that play? When the allegation falls apart in criminal court, how does that play?
Well, I think it's a dichotomy of it. So, of course, there's to be a good offensive coach, you got to see the defense. To be a good defensive coach, you got to see the offense. So, of course, if I'm the parent or if I'm the lawyer who's representing the parent who wanted these allegations to stick, hey, they were arrested. Hey, DCF was involved. Hey, they took it seriously. Judge, there may not have been enough evidence to convict, but it's still not in the child's best interest, and we're only dealing with the preponderance. And they'll browbeat that, they'll push it, and continue to push it. On our end, well, first off, if it's like a no information, the state dismisses it. Hey, judge, I'm going to put that into evidence. I'm going to get a certified copy that's going in. If it's a, not guilty, I'm going to get the, the judgment and the, outcome, and I'm going to get that, and I'm going to definitely be putting that in. But then a lot of the times I will try, and hopefully that, there's a court reporter and a transcript, and get the transcript and really look through what happened on cross-examination. And if, look for, if the victim admits, like, my dad made me say this, or my mom told me to say this, or, then, of course, going through that line by line, and then, following the breadcrumbs, the criminal defense attorney has left me in the nuggets of gold along the path, to rebuild that case. But I always have to keep in mind that I'm dealing with a preponderance. So I have to prove it. It's not whether you're guilty of a crime or not. It's just, is it best for the kid to have this much time around you? Or is it best for the kid to, and that's a much lower standard. You could have somebody who's not a nice person, that's not a criminal, and maybe it's not a good idea for the child to have that much time around that person. So it's a much lower standard. Now, if it gets into, my mom told me to say this, or my dad told me to say this, or I've seen DCF chime up with, if you report anything else again and we find it unfounded, we're going to prosecute you because that can be a crime. Then I'm going to, go into that 6113, and I'm going to look for the section of the statute that deals with false accusations, and explain to the judge that, having my client interchanging, and exchanging the child and interacting is just going to continue to subject them to being, made a false, have these false allegations made against them, and I'm gonna go there with it. But you know, the best thing is always, the acquittal. Sometimes, it's hard for me because the criminal attorney may be advising someone to take a plea or even even what we call a pretrial, if it's a misdemeanor or even a smaller, pretrial intervention. If you don't do anything bad for 60 days and you pay the fine, or basically behave for a year, we'll let this go away. Obviously that's not usually on sex allegations or hard abuse allegations, usually smaller things. It puts me in a pickle because my criminal mind from being a criminal defense attorney, going back in that world, is like, don't look the gift horse in the mouth. This is going to be over for you in 60 days and it's going to get dismissed. My family law mind's going to go into play and say, it got dismissed with strings attached because you did X, Y, and Z. And I'm going to make hay about that in court, that it wasn't a clean dismissal or a clean acquittal. It was, conditioned on you doing these things. So, but, Rusty, time flies every time I get to talk with you. We've been at it for about an hour now. So, but Rusty, I want to just thank you for, coming out today and doing the podcast with us, and, sharing your experiences with us. And this topic is one that comes up so often. We're definitely going to have some follow-ups, because I feel like today we just kind of almost just scratched the surface of this. But before we leave, Rusty, what's the name of your firm?
Shepard Law. We're on 15th Street in Panama City, the St. Andrews area, near the intersection of 15th and back.
And if people have questions regarding any of these issues, or might find themselves in one of these difficult positions, what's the best way to get in touch with you at your firm?
Our phone number is 850-215-5200. We have a 24-hour hotline, as you know, because it happens with family law, but family law and certainly criminal law, it takes place, a lot of it during the night and on weekends. So we certainly answer our phone, and we are available for consultations.
All right. Well, Rusty, I appreciate you coming out, and this will not be the last time, I'm sure, because like we could talk about this for several episodes,
Good. And
and
we
the law
do.
is always changing. So, all right, Rusty. Well, you have a good weekend, and we look forward to having you back on. Okay.
Thank you, Gerard. I appreciate you.
Thank you.